More than 200 years ago, Americans fought a revolution against big government.
With me here now, just down from the 9th floor, is attorney for two of the plaintiffs, Gary Kreep. What would you say is your take on this today, Mr. Kreep?
I think it's all up in the air. I had expected the judge would have decided by now, but he made it very clear that he's taking it under submission and he will issue a decision sometime this week, and we're just now in waiting mode. No matter what happens in this decision, the loser, I'm sure, will appeal. The Department of Justice will appeal if we win, if the case survives. If the case does not survive, then I will be filing an appeal on behalf of my clients.
And your two clients are?
Pastor Wiley Drake and Mr. Markham Robinson. Pastor Drake is a local pastor, and he was the vice presidential candidate for the American Independent Party in the 2008 presidential ballot. And Mr. Robinson is the current state chairman of the American Independent Party.
Judge David O'Carter made a lengthy discussion as to whether he felt that had much credibility, because even if they'd won in all the states they were on the ballot, they could have not got enough electoral college votes. Is that a relevant argument for the judge to make?
No, and I, as unfortunately due to some problems, I was late to the court. I did not hear that argument. However, I was advised by my client of it. So when I had one of my speaking opportunities, I raised that issue, and the judge backed off. He acknowledged that that was not a relevant argument because it's got nothing to do with what would have happened. It was a static analysis rather than a moving analysis. In other words, you could say, well, if Mr. Obama hadn't got all those votes, John McCain would have won. Well, but that's not necessarily true, because there would have been different candidates. It could have, as I pointed out in the courtroom, the people could have been so upset with both parties, as they really were last year, that a third-party candidate would have won, or would at least have held the balance of power. So that argument that the judge made initially and later retracted was not appropriate.
So where do you think it stands in his mind as far as your arguments to the court? Is he likely, do you think, to rule that you have standing and then deal with the political question in the jurisdiction? Or is he satisfied? Is he going to have another hearing on jurisdiction and the political issue?
I don't know. I've been an attorney for almost 34 years, and I gave up a long time ago prognosticating about what a judge is going to do. So we'll just have to wait and see. It's all in God's hands anyway.
Do you feel Judge Carter gave you an honest hearing today?
Yes.
Do you feel the people of America, if they had had a bird's eye view as we had, do you think they would have been felt that the judicial federal court was dealing with this fairly and squarely?
Yes, I would. Dr. Taitz has been given in all these hearings much more latitude than if I was sitting as a judge I would give her, because she's gone off on a lot of extraneous things. But he gave her every moment to talk. He let her say everything she wanted to. He let me say everything that I wanted to. My arguments were much shorter because I was dealing with specific issues in the motion, because a lot of the motion for dismissal was aimed directly at Dr. Taitz's clients, not at mine. So I just dealt with the issues that affected my clients. A website is www.usjf.net, www.usjf.net.
Okay, and now back to this issue. If the court goes forward and says, yes, you've got standing, you raised a valid point that if Congress can't deal with it, and there is an issue, and I grant that you have standing, we're going forward. What's the next court date we're going to be back here?
Well, the next thing, request filed for various discovery. As I said in open court, we've already made arrangements with a Hawaiian attorney. We'll be bringing him in, associating him in, filing a motion to bring him in pro hoc vice, so that he can represent us, I and my two clients, I should say, not me, but my two clients, in Hawaii, to issue subpoenas to get the records that we're seeking from various entities in Hawaii, including Mr. Obama's elementary school, his high school, and the Department Public Health and the Public Health Department of Hawaii. But I expect that what will happen almost immediately is that if the motion is not completely successful, and I mean 100% successful, that the Department of Justice will be filing an appeal. They're not going to allow any discovery to go forward. They're going to do everything they can to block it for obvious reasons. If we're able to get the documents to show that Mr. Obama is not eligible to serve as president, you know what's going to hit the fan.
You made a very elegant argument, I think, that if fraud was committed and he doesn't have the legal right to be president, then he's not president, in that case, why would the U.S. attorneys have an obligation to defend him since everything he's done in the Oval Office is a fraud?
Well, the problem is that when Dr. Taitz brought her lawsuit, she sued a number of government officials in their official capacities. That brought the Department of Justice in. If she had just sued Mr. Obama personally, the Department of Justice would not have come in. It would have just been a matter of Mr. Obama's private attorneys that he's been using in all the other cases coming in and defending him.
Anything else you want to add here today on October 5th?
It's going to be an interesting week. We're going to see what the judge rules. I expect to receive a decision sooner rather than later, and then we're off to the races.
There's going to be appeal either way in your view.
Yes, no doubt in my mind.
That's the word from attorney Gary Kreep here from Ramona, California. We're at the Ronald Reagan Federal Courthouse. Thank you very much, sir.
Thank you for having me on your show. God bless. Bye-bye.
This is William Wagener. With us now is the other plaintiff attorney who has a lot of clients, the beautiful Orly Taitz, who's also a dentist and an attorney. And I just heard today you became an attorney because you saw constitutional issues coming up?
Well, no, I've been an attorney for 10 years, but I was not a constitutional lawyer, and I took this issue specifically because the constitutional rights of the citizens are just taken away time and again. The right to enforce the Constitution, to have legitimate president.
Okay. Orly, you made a valiant argument on the fraud issue. Did you feel Judge Carter was steering you away from the fraud issue?
Absolutely. He didn't want to hear that. I felt that he wanted to limit the argument, and it was not the same Judge Carter that I've seen in July and not the same Judge Carter that I've seen in September. In September, he clearly stated to the government that motions to dismiss due to lack of standing are usually not granted 96% of cases. He let them understand that he does not believe it will be granted. Moreover, in July, I had an opportunity to have a default, and because I have served originally Mr. Obama as an individual for something that he did for fraud committed by him as an individual before the election. And the U.S. attorneys showed up in court as an intervening party representing United States of America and demanding to be served. And at that time, Judge Carter stated, well, please serve them. I assure you this case will not be dismissed on technicality. It will be heard on the merits. So I was prepared, if I did not get a default then in July, to appeal and seek a default. And the only reason I did not appeal then was because Judge Carter has assured me that the case will be heard on the merits. It would not be dismissed on technicality. And he stated, if you don't serve them today, they will appeal, the case will get dragged. And that was the understanding. So I think he's
backstepping? Is he moving backwards, trying to retract his early? I heard the same thing on September 8th, that it would be heard on the merits. And I think there was at least 80 other people in that courtroom heard the same thing. Now he seems to be taking a position that standing has to be established, then the political issue has to be determined, and then jurisdiction. It didn't seem like the same Judge Carter to me.
Absolutely.
And I sat there through the whole procedure on the 8th.
It looked and sounded there was some kind of influence because he spoke completely differently from the way he spoke in July and September.
That was my gut feeling, and there were people, me in the courtroom around me. I was in one of the overflow rooms, and that's another thing. There were 2 overflow rooms today. The crowd is gaining in mass, and it did seem the judge was backpedaling, trying not to let it go forward to the merits, and I was amazed that he even vocalized it, and he said out loud, President Obama has not called me and exercised any influence